Hello everyone, Kit here, back with another video. Today for you guys, I'm going to be reading the County Sheriff's Handbook. I'll leave a link to this down in the description box below, along for email. You can email us at themoney@gmail.com for proper consultation. Now without further ado, let's get right into it. The County Sheriff's Handbook. With a firm reliance on the protection of the divine providence, we mutually pledge to each other our lives, our fortunes, and our secret honor. Thomas Jefferson. Government is not a reason. It is not eloquent. It is force, like fire. It is a dangerous servant and a fearful master. George Washington. In matters of power, let no more be heard in confidence in men, but bind him down from the mischief by the chains of the Constitution. Thomas Jefferson. I swear upon the altar of God eternal hostility to every form of tyranny over the mind of man. Thomas Jefferson. Timid men prefer the calm of despotism to the tempestuous sea of liberty. Thomas Jefferson. Duty of the County Sheriff. The sheriff is to support and defend the law of the land, aka the Constitution, and the laws of nature's God, aka common law, by which the former is vested by we the people who are vested in by the latter, not legislative bodies. We are a nation governed by the common laws of God, which makes our law superior and more just than any other nation's law. Therefore, the oath of the county sheriff is a sacred oath which, when violated, is a direct assault upon God whose judgment will not rest forever. Thomas Jefferson professed America's covenant between God and we the people, when he penned the following. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal nation to which the laws of nature and of nature's God entitle them. Decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Sheriff and the Court. The court belongs to the sovereign people. The United States Supreme Court defines the court as an agency of the sovereign, the people created by it, the people directly or indirectly under its authority, consisting of one or more officers, magistrate, sheriff, coroner, and prosecutor, established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise its powers in the course of law at times and places previously determined by a lawful authority. State and county courts are courts of record. In some cases, city courts are courts of record. For instance, New York City courts are courts of record, but all other city courts in New York State are not courts of record. To find out what courts are courts of record, look in your state constitution. All other courts are called nisi praetor courtes, also called administrative courts. These courts are not courts of record. Unless your state constitution says differently, all city, town, and village courts are not courts of record. Wherever's law defines nisi praetor courtes, where courts bearing the name exist in the United States, they are instituted by statutory provision, not constitutional. Nisi prius is a Latin term in Black's law. States primus means first, nisi means unless. A nisi prius procedure is a procedure to which a party first agrees unless he objects. A rule of procedure in courts is that if a party fails to object to something, then it means he agrees to it. A nisi procedure is a procedure to which a person has failed to object. A nisi prius court is a court in which will proceed unless a party objects. Nisi prius court is a court which will proceed unless a party objects. The agreement to proceed is obtained from the parties first. The United States Supreme Court said concerning courts of record and courts not of record, the former being those who acts and judicial proceedings are enrolled or recorded for perpetual memory and testimony, and which have power to fine or imprison for contempt. Courts not of record are those of inferior dignity, which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. The sheriff has a duty to provide law enforcement officers in all courts of record, often called bailiffs, which means guardian or steward, who are who are a sheriff's deputy in all courts of record. Like the sheriff deputies are to have a proper education, it is the duty of the sheriff to make sure that his deputies have a proper education. The bailiff is not in the courtroom as a private bodyguard for the judge. She is there to protect the people and the judge who is also one of the people. He is there to keep the peace by making sure the law of the land is being adhered to and that unalienable rights are not being violated. If the sheriff perceives that the judge or any other elected or appointed official for that matter is breaking the law, the best way to proceed is to get an indictment before making an arrest. Don't trust the gatekeeper because he is likely to help the judge. Judges and prosecutors are both elected, both political, both bar members, both lawyers, and have a close working relationship, and therefore are likely to share a camaraderie. Go see the grand jury directly and secure an indictment. Court duties. Sheriffs are responsible for maintaining the safety and security of the court. A bailiff is required to attend all court sessions, take charge of juries whenever they are outside the courtroom, to serve court papers, to, extradite prisoners, extradite I think that says, and to perform other court-related functions. Sheriff and warrants. Amended, Amendment 6. To the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized. According to Black's Law Dictionary, the word oath, in its broadest sense, includes all forms of ascension by which a party signifies that he/she is bound in consistence by a solemn and formal declaration or asseveration that an affidavit is true. No warrant, including a federal warrant, is to be served without going through the sheriff's office. Any warrant without a sworn affidavit and judge's wet ink signature, not a stamp, is not executable warrant. It is the sheriff's duty to make sure that all warrants, federal or state, served within her county passes constitutional scrutiny. IRS warrants rarely pass constitutional scrutiny. For example, the IRS has a Form 4490 called Proof of Claim for Internal Revenue Taxes, which is an affidavit form that must be filled out and sworn to, without which the warrant with the wet ink signature is not executable. Sheriff and the County Jail. Sheriff's officers maintain and operate county jails or other detention centers, community corrections facilities such as work release, and halfway houses. Sheriffs are responsible for supervising inmates, protecting their rights, and providing food, clothing, exercise, recreation, and medical services. Before the sheriff is to accept any prisoner, he is to make sure that the due process has been exercised. If a court sends a prisoner sentenced to be incarcerated, and there was no indictment and petit jury trial by 12 jurors before the sentencing, the prisoner is now a victim who was not given the due process. The sheriff cannot accept that prisoner. Unfortunately, because of ignorance, county jails are filled with such prisoners. Black's law defines an infamous crime as a crime punishable by imprisonment. Amendment 5. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Amendment 6. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury. The sheriff cannot accept any prisoners that were tried in courts, not of record. Plus they are near nisi prius courts and do not have the power to fine or incinerate. The sheriff cannot accept any prisoners that were tried in courts, not of record, because they are nisi prius courts and they do not have the power to fine or incarcerate. Sheriff is the chief law enforcement officer of the county. The sheriff is the chief executive and administrative officer of a county, being chosen by popular election. His principal duties are in aid of the criminal courts and civil courts of record, such as serving processes, summoning juries, executing judgments, holding justicial sales, and the like. He is also chief conservator of the peace within his territorial jurisdiction. When using statutes, the term may include a deputy sheriff, Lehner versus Town of Greenville. Justice Scalia, writing for the majority in a 1997 decision, said that the states are not subject to federal direction, and that the U.S. Congress only had discrete and enumerated powers, and that federal impotency was rendered express by the 10th Amendment. He further confirmed that the sheriff is the chief law enforcement officer of the county, and also proclaimed that the states retain an inviolable sovereignty. Scalia even went further in his landmark decision in one in which two small town sheriffs headed the feds off the pass and sent them on their way. Scalia, in his infinite obligation to the Constitution, took this entire ruling to the 10th power when he said, "The Constitution protects us from our own best intentions, so that we may resist the temptation to concrete power in one location as an expedient solution to the crisis of the day." Obviously, the sheriff is the people's last line of defense against the government gone rogue. Law enforcement. A sheriff always has the power to make arrests within his or her own county. Some states extend this authority to adjacent counties or to the entire state. Many sheriff's offices also perform routine patrol functions such as traffic control, accident investigations, and transportation of prisoners. Larger departments may perform criminal investigations, and some unusually large sheriff offices command an air patrol, a mounted patrol, or a marine patrol. Sheriffs still enlist the aid of the citizens. The National Neighborhood Watch program, sponsored by the National Sheriff's Association, allows citizens and law enforcement officials to cooperate in keeping communities safe. This is why the new mission of the Indiana Sheriff's Association and the slogan is "Building Communities of Trust in all 92 Indiana counties." As the sheriff's law enforcement duties become more extensive and complex, new career opportunities exist for people with specialized skills underwater diving, piloting, boating, skiing, and radar technology, communications, computer technology, accounting, emergency medicine, and foreign languages, especially Spanish, French, and Vietnamese. Just courts of law rest upon six foundational truths. Truths are self-evident. All men are created equal. We are in we are endowed, gifted by the Creator. We have unalienable rights. To secure these rights, we have a right to institute governments, constitution. Governments had the governments that derive their just powers from the consent of the people, wherein we ordained and established the following: we, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, and provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity. Do ordain and establish this Constitution for the United States of America. Preamble to the Constitution for the United States of America. Therefore, by the powers vested in we the people by God, we the people do we the people did order and establish vested powers to our government, servants who are bound by the chains of the Constitution through their oaths to the following six ends alone: form a more perfect union, establish justice, insecure domestic tranquility, provide for the common defense, promote the general welfare, secure the blessings of liberty to ourselves and our posterity. No legislation is to pass that does not in the end serve one or more of the aforesaid six ends. Any legislation to the contrary is null and void, and the sheriff is bound to treat it as such under the following general rule. General rule. The general rule is that an unconstitutional statute, through having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since its unconstitutionally dates from the time of its enactment. In legal contemplation, it is as inoperative as it has never been passed. Since the unconstitutional law is void, general principles follow that it imposes no duties, confers no right, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A void act cannot be legally consistent with it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing law. Indeed, insofar as a statute runs counter to the fundamental law of the land, the Constitution, it is suspended hereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Monette versus Baylor. Any sheriff unable to understand and enforce the general rule violates his oath of office and wars against God and we the people. For the sheriff to correct this error, there are only two choices: one, study and show thyself approved by your oath, or two, resign the office of sheriff. It is also the duty of every sheriff to train their deputies in the law of the land. This is the very purpose of this book, to train up our sheriffs and deputies in the way they should conduct themselves and not depart from it. It has become agonizingly obvious through communicating with many sheriffs and their deputies across the nation that the majority of them are not properly educated and do not understand their oath and authority. Law of the land. Law. That which is laid down, ordained, or established. Keon versus Flynn. U.S. Constitution Article 6. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made of, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, are notwithstanding. In conclusion, law is all about the securing of unalienable rights. We do not need a PhD to know and understand the law. We need not yield our understanding to statutory lawyers, aka bar attorneys. The Bible tells us that lawyers reject the counsel of God. They lay upon men grievous burdens and take away the key of knowledge. The Bible tells us that God has written his laws in the hearts of all men. We the people know we the people can know right from wrong. We do not need legislators and lawyers to tell us. That is precisely why we the people never gave our servant legislators authority to write statutes and govern our behavior. Nor do we give judges and prosecutors the authority to indict or judge we the people that authority. We reserve to ourselves via unattained juries with the power of nullification. Common law is built upon logic and reason through maxims and principles. Maxims are self-evident truths such as all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. For every injury there must be a remedy, and for there to be a crime there must be an injured party. Principles are a state Principles are a state of mind that needs to be considered such as honor, justice, and mercy. Likewise, we need not yield our trust in understanding law to bar attorneys. Thomas Jefferson told us, laws are made for men of ordinary understanding and should therefore be constructed by ordinary rules of common sense. Their meaning is not to be sought for in metaphysical subtleties, which may take anything mean which may make anything mean everything or nothing at pleasure. The purpose of a written constitution is entirely defeated if, in interpreting it as a legal document, its provisions are manipulated and worked around so that the document means whatever the manipulators wish. Jefferson recognized this danger and spoke out constantly for careful adherence to the Constitution as written. The changes to be made by amendment, not tortured and twisted interpretations of the text. A rule of thumb considering the constitutionality of any legislation or interpretation of the Constitution is to ask if the conclusion violates any of our unalienable rights, and if it does, it's null and void. The laws of nature and of nature's God. The laws of nature and nature's God is called natural law or common law. So called because the law is common unto all men, and no one can escape its judgment, which will be applied to either in true courts of justice or on the last day. According to Black's Law, 4th edition, the key phrase in law means in the indictment or completion of the law existing in law or by force of law. It is in fact actual, real, as distinguished from implied or inferred. Philosophically, it seems more correct to say than the word land means. In law, as the vernacular, the soil, the term land may be used interchangeably with property. It may include anything that may be classed as real estate or real property. Renyon versus City of Caldwell. Law of the land lifted from Magna Carta means due process. Process due and owing to all concerned. Sometime called the paths of the law. Therein the constitutional phrase law of the land, property, for it is God who created all things for his pleasure, and said, the world is mine. All men are mine. All souls are mine. And all gold and silver is mine. We the people and all creation are God's property. God is the lawgiver and the judge, who gave us the law of liberty, via unalienable rights, thereby making us free. and we the people, through the jury, grand and petit, sit as the tribunal on the king's bench to exercise the law of the land, and no man, by way of legislation or decree, can take the we the people's liberty without consequence. Black's law states that the phrase law is used to point out a thing that is to be done according to the course of the common law. It is distinguished from a proceeding in equity. Law is that which is laid down, ordained, or established. Thomas Jefferson was a student of Lord Bolingbroke. He first began studying Bolingbroke's writings at the age of 14, and he read them again at the age of 23 as he was preparing for a career as a lawyer. Jefferson's literary commonplace book contains more quotations from Bolingbroke than, than from any other author, and all historians have given Bolingbroke the credit for Jefferson's famous phrase regarding laws of nature and nature's God. In a renowned letter to Alexander Pope, Lord Bolingbroke wrote the following words, which were to become the basis for Jefferson's opening paragraph of the Declaration of Independence. You'll find that it is the modest, not the presumptuous inquirer who makes a real and safe progress in the discovery of divine truths. One follows nature and nature's God. That is, he follows God in his works and in his word. Here we find a definition from the very individual that all scholars recognize as a source of Jefferson's phrase. According to Lord Bolingbroke, the law of nature's God is the law which is found in God's word. This is the definition which was intended by Jefferson, and this is the manner in which his words were understood. This was the definition which was intended by Jefferson, and this was the manner in which his words were understood by our forefathers. The law of nature's God upon which our nation was founded is nothing less than the Bible itself. The laws of nature are most perfect and immutable, but the condition of human law is an unending succession, and there is nothing in which it can continue perpetually. Human laws are born, live, and die. As one might expect, the Bible is fairly clear on the subject of the supremacy of God and his law. It indicates that there is no God except the Lord God. God is the God of creation, and he is the creator of all things visible and invisible. God impressed his laws upon creation, and he governs its operation accordingly. God gave his laws so that people would seek after God and know what God requires of every person. Of course, the laws of God are right, perfect, and eternal. They apply over the entire globe and are written in God's creation because God is the creator of all the earth. These rules also apply to all people and are written within each man, woman, and child because God is the creator of all people. God also reiterated the basic elements of his rules of right and wrong in the Bible. The implications of this situation are straightforward. Since God created all things, he has the right to rule them according to his laws. He rules the nations according to his laws. His laws rule the nation irrespective of whether a given nation believes in God or recognizes his laws. This does not mean that the nations are perfect, nor does it mean people who do not worship God cannot rule. Nor does it mean that God will judge lawbreakers according to our timetables of justice. It does not mean, however, that God will not let a corrupt government rule forever. God judges justly on the earth and punishes lawless leaders in nations. Nations which forget God may completely perish. Nations which honor God and try to follow his laws, however, can expect to receive his care and protection. Legislative law is vested law. Neither the U.S. Congress nor any state Congress has the authority to write statutes that control people's behavior. It is up to the people to control their own behavior, and if they injure someone, the common law has remedies. Vested authority in our legislators is found in Article 1, Section 8. Congress absolutely has no authority to legislate outside of Article 1, Section 8. The real law. The common law is the real law, the supreme law of the land. The code, rules, regulations, policy, and statutes are not the law. South versus Ray. Alright guys, I'm going to end this off. This will be part 1. I'll see you guys in the next video. Once again, I'll leave a link to this down in the description box below. One for emails at themanagergmail.com for private consultation. I'll see you guys in the next video. Have a nice day.